is it a good idea to think about drafting your patent application by your own, or you really need to have the advices of experts? Because when I'm speaking with different people, some of them say, okay, I could write a patent by my own. What's your point of view?
But if you are an inventor and you are a scientific inventor and you're used to write publications, scientific publications, then you are already halfway, because a patent application needs to disclose your invention as in all the details as possible. For example, there is a requirement in the US that it really has the requirement to include in your patent application the best mode of your invention. So there is not a possibility to cheat, especially not if you go to the US. You should disclose your invention as good as you can. And probably if you are an inventor who is doing, for example, a PhD, or which has already obtained his PhD, or which is a professor, normally these people should be able to write at least 50% of the applications themselves. Now, the problem is often that we write from a scientific view, as a scientific, while patent attorneys write from a legal point of view. They, frankly spoken, they often don't care what the details of the invention is. They try to maximize the scope of protection. Is it useful to use a patent attorney? I would say yes, for providing the legal certainty in drafting claims, and especially for having at least a quick review of the rest of the disclosure. The difference between a scientific publication and a patent application is really the point of view of the inventor. Normally, a PhD who is making a publication, he's writing the publication as of he has already the knowledge of the invention. So if I sometimes compare it with climbing onto a mountain. If you would climb to a mountain and you're on top of the mountain, then it's easy to explain how you reach the top of the mountain. While a patent application is written without the knowledge how to climb to the top, but you are still down, and then you are describing all the difficult problems that you have to overcome in order to reach for the top, which is a different point of view.
So recommendation would be you start describing the best as you can the invention, and then you request the help of the patent attorney to review that part and to start drafting the claims and what will define your legal protection in a certain way.
Yes, I would say so, especially if it's the first or the second time that you draft a patent application. But it would be nice if the inventor could be engaged in a learning curve how to draft patent applications.